Good morning. Today I'm going to look at a recent important decision of the New South Wales Court of Appeal. Justices Barrett and Gleeson and President Beasley. Case called Dion, D-I-O-N Investments Proprietary Limited, 2014 NSWCA 367. Decision given at the very end of October. And it's looking at the question of the power of the court to permit an amendment to a trust deed pursuant to section 81 of the New South Wales Trustee Act 1925. And interesting decision because in it the court limits the ability of the court to confer new powers on a trustee, to alter, amend, vary, etc., the actual terms of a trust, even though it may be possible pursuant to the section to make certain orders with respect to, say, trust property or some other payment of money which is going to be beneficial to the beneficiaries. And the case involved a pretty old trust, and the trustees, because of the way in which the income tax position was now operating, wanted to have the ability in terms of capital gains tax and the like to allocate the beneficiaries' capital gains if there was no income received, and various questions of ascertaining the powers in terms of what was income and what was capital. Things, of course, that hadn't occurred to the trustee stroke set law way back in 1970 odd. And at trial, when they went up for some directions and to try and get these orders, they also sought an order which would permit the trustee, with the consent of any appointor, although there was none in this case, to revoke, add to, vary or alter all the trust's terms and conditions of the deed, to revoke and vary new trusts concerning the trust fund, etc. And it was that last provision, that last attempt, that last order, which was just a step too far in terms of Justice Barrett's judgment. Reg Barrett gives the main judgment, and Justice Young, sitting at trial, acting as a judge, had held that he didn't have power pursuant to section 81 to extend the general operation of the trust. And the case really turned on what the meaning of a transaction was in terms of section 81. Section 81 provides for trustees to be able to do a number of things via the court. And paragraph 88, Justice Barrett points out that the court may, under section 81(1), confer upon the trustees, either generally or in any particular instance, the necessary power for the purpose of effecting in the management of the trust property any sale, lease, mortgage, surrender, release or disposition, or any purchase, investment, acquisition, expenditure or transaction that cannot be effected by reason of the absence of any power for that purpose vested in the trustees by the instrument, if any, creating the trust or by law. So you can see there were two distinct classes, if you like, of order contemplated by section 81. And over the years, we won't look at all the authorities. Justice Barrett, usual style, very detailed analysis of all the earlier cases. A flavour grown up in the cases, although there was no direct Court of Appeal authority. But the word transaction at the very end of the sentence there, talking about expenditure or transaction, authorised in an indirect way the court to add to, vary or revoke the actual powers of a trust itself. In other words, transaction wasn't read justum generis as one might have expected in terms of payment of money or the like for expenditure and acquisition, but rather was a broad dispositive or altering power. And the Court of Appeal has now said that that is not right. Justice Young was correct, and that in fact that last word transaction isn't broad enough to permit the court to add to the powers or vary the trust operation, except in terms of a particular thing which the trustees propose to do. So you've got no general power to come along and say, as they sought here, let me alter, vary or amend anything in any way I like. You can't do that. It seems that you've got to bring before the court a particular transaction or alteration which the court may consider is appropriate. And Justice Barrett notes at paragraph 89 that the dealings which section 81 contemplate fall into two classes, each of which is reduced by the word any. The first class consists of any sale, lease, mortgage, surrender, release or disposition. And as he points out, each of these words describes the dispositive act of an owner of property by which the property or some other interest in it passes or accrues to another person. Dealings within the first class are thus of their nature dealings of a kind engaged in by the owner of property or trustees in whom property is vested. Paragraph 90, the second class of dealings is delineated by the words any purchase, investment, acquisition, expenditure or transaction. And ignoring for the moment the word transaction, these words concentrate principally on ways of deploying money. But it's certainly the case in relation to purchase, investment and expenditure, and will very often be the case in relation to transaction. For example, subscription of shares or other securities. Now, as is on our notes, paragraph 91, transaction of itself does not imply an outlay of money, nor should any such limitation be taken to be indicated by the fact that reference to transaction comes immediately after references to purchase, investment, acquisition and expenditure. A transaction that in fact involves an outlay of money is certainly in contemplation, but so too, in my view, is the one that does not. And Richard White, writing extrajudicially, had suggested that transaction should be construed eustem generis. So looking at the earlier words, of course, but that was not the way in which the matter had been interpreted in the subsequent cases, the later cases. Paragraph 92, though, although transaction is a very wide expression, power for a trustee to effect a particular transaction may be supplied by the court only if, in the management or administration of any property vested in a trustee, the transaction is, in the court's opinion, expedient. And picking up Justice Dixon, Sir Owen Dixon in Riddle and Riddle, that is talking about the interest of the beneficiaries, which is advantageous or desirable. But in every case, the expediency is tied to the management or administration of trust property. Now, just note there in passing, we won't look at it, but there is a wider definition in Queensland. The Queensland Act doesn't follow the old 1925 Act in England precisely as New South Wales does. And in Queensland, you can look simply at what is in the best interest of the beneficiaries. And that gives a greater scope in Queensland, but not in New South Wales or Victoria. So, what's the result? Well, paragraph 94. Variation of the terms of a trust, including by way of conferral some new power on the trustee, is not something within the ordinary natural province of a trustee. It is not something that is expedient that a trustee should do, nor fundamentally is it something that is done in the management or administration of trust property. Trustees' function is to take the trust as it finds them and to administer them as they stand. The trustee is not concerned to question the terms of a trust or to seek to improve them. I venture to say that even where the trust instrument itself gives the trustee a power of variation, exercise of that power is not something that occurs in the management or administration of trust property. It occurs in order that the scheme of fiduciary administration of the property may somehow be reshaped. So, looking here, there were earlier cases, as I've said, dicta suggesting that transaction was broad enough to cover putting in broader powers, if you like, to vary, revoke, etc., etc. But in this case, the court makes it clear that that would not be appropriate. And paragraph 97, conferral of specific new powers, pursuant to section 81, should not be by way of purported grant of authority to amend the trust instrument so that it provides for new powers. Rather, the court order should directly confer and be the sole and direct source of the powers, and as necessary override the content of a trust instrument. And of course, the only specific powers that can be conferred in that direct way are those that fall in section 81 concerned with the management and administration of trust property. And then subsequently the court goes on and looks at various proposals here in relation to altering income, etc., etc. Those all involve, of course, payment of money or some incidental issue with respect to the property of the trust. So those orders, as Justice Young had held, were within power in terms of section 81, but the general proposition, which was the last broad alteration, as to say a power to revoke and vary and add new trusts, etc., that was not within the power. And in paragraph 98, Justice Barrett says, if under the guise of giving the trustee a power to undertake a transaction of amending the trust deed by adding a comprehensive and virtually unrestrained amendment provision, an order is made that purports to put the trustee into a position from which it can make all and any alterations to the terms of the trust it thinks desirable, the court takes the impermissible course of both appropriating to itself and giving to the trustee a general power to depart from the precise directions that a set law thought proper to declare. Because there is no proposed transaction which is specifically related to management by trustees of a trust property, quo ad property, the matter is not within the scope of the section. Well, a pretty important decision, I think. It's an important decision because for about 10 years an idea had grown up that you could go along to the court, take out a trustee summons section, come up to court section 81, and in a way, using transaction in the broader sense, you could slip through, as it were, very broad powers of amendment to the trust. Clearly you can't do that. It's a practical matter, though it won't really have much impact, I don't think, because it seems likely that in respect of any income tax or other reason, valid reason to improve the beneficiary's position in terms of the way in which you're treating monies that's received or properties owned by the trust, but you'll nevertheless be able to come in and get a particular order through the court in terms of the terms of section 81, and that's because almost every sort of order will be quoad, that's to say in relation to property, quoad, Q-U-O-A-D, good old Latin word. I won't go into details there, think of a funny thing, but quoad property, no problem. So if you're involved in this area, have a good look at the case. It means that you'll need to be a bit more circumspect in terms of drafting, but I guess in a way it really confirms the broad width of section 81, and of course if you're in Queensland you have an even greater opportunities. You've got wider powers, wider scope for variation.